record label's perspective, where do the sort of generally what we call name and likeness rights of the artist, how do they fit in, and who owns them and who controls them, and do you need to address them or not? The general rule is that in a record company contract, the record company generally contractually gets the right, and this is a right that is separate and apart from, as you said, the ownership rights and the master recordings or the musical compositions. It's sort of this nebulous sort of trademark directed right. Usually, the starting point is that the record company should have promotional rights, the right to use the artist's name and likeness, logo, trademarks in connection with the promotion of the product that they own, right? So that's number one, and that really should be spelled out in there, because maybe there's supposed to be some approvals on behalf of the artist, so from the record company's behalf, you want to make sure you got those rights. On the artist's behalf, you want to make sure that you've at least got a little approval over it. Does the record company have the right to go beyond that, is the question. Can you... Okay, the correct terminology usually is not usually the record company cannot own the trademark name of the band. It's usually not an ownership because it doesn't fit trademark law. But can the record company have licensing rights? You can, and there is that promotional level of licensing rights we just discussed, but there is a commercial level of licensing rights that we just discussed, which is commercial merchandising rights. Can you be the merchandiser on behalf of the band? And the answer is yes, if it's in the deal. But if it's not in the deal, the answer is no. The band is going to retain their merchandising rights. And the ownership of the band name virtually always should stick with the band.
Perfect. Thanks so much.
All right, thank you guys.